I appreciate that. Mr. Weinstein, you mentioned the possibility of enacting a provision to prohibit the disclosure of classified information by government employees, regardless of the damage to national security. What are the pros and cons accompanying such a statute? And do we run the risk of inviting more classification than currently exists in an effort to prevent dissemination of, say, unsavory but not necessarily damaging material?
That's a very good question, sir. And that actually harks back to something that Abby Lowell mentioned about how back in 2000 there was that statute was passed, actually, and then President Clinton vetoed it. And the statute basically said if you're a government employee, you sign that non-disclosure agreement and you disclose classified information, something that says secret, then you're guilty. The pro is that that's very clean. You don't have to show damage. You don't have to get into this back and forth of whether it was damaging to disclose secrets about the Iraq War or good because the Iraq War needed to be examined more closely. It's just clear. You have a responsibility as a government employee to protect classified information. You willingly and knowingly disclose it, you're guilty. So that's on the pro side. The con side, of course, is that, as you pointed out, there's so much information that's classified that it would be chilling to many government employees when they're going to talk to people that, gee, all it takes is one step over the line and I get into one iota of classified information and I'm guilty. You know, if I intentionally disclose that, I can't talk about anything. And so one of the cons is that, you know, it'll end up, people will be scared to talk to the press, people will be scared to talk to Congress because they're worried that they're going to trip over classified information. And you might have people who will be prosecuted for information which, though classified, as you pointed out, might not really be all that sensitive. It might just be either a matter of mistaken overclassification or something which is embarrassing but not really sensitive.
Thank you for that, sir. Mr. Schoenfeld, is it your belief that the First Amendment confers on journalists an absolute right to publish classified information or government secrets?
No, it is not. And I think, from what I've heard on the panel, there's some agreement with me that under some circumstances, journalists can be prosecuted under the espionage statutes. And the Chicago, just to hark back to the Chicago Tribune case, we have a case where I think the espionage statutes would apply if a story came out that cost the lives of tens of thousands of U.S. servicemen and prolonged the war. So I think, and the Supreme Court, of course, in the Pentagon Papers case, 5 of the 9 justices I had noted earlier did suggest that if the case came to them not as a prior restraint case, but after the fact as an Espionage Act prosecution or a Section 798 prosecution, they would strongly consider upholding a conviction if the material at issue was the material that Congress had indeed prescribed under those statutes.
I got you. Thank you, sir. Professor Stone, we touched on this, but let me run it by you again. Does WikiLeaks enjoy the same protections as traditional journalism organizations, A? And in the Internet age, how do we distinguish between traditional media and the new media? And does the law contemplate such distinction?
I think realistically it's impossible to do that. The Supreme Court itself, in interpreting the First Amendment, has always refused to define who the press is. And in any event, the speech clause, as has been noted, is an independent protection. So although that may be frustrating, I think as a practical reality, there's no way to distinguish WikiLeaks from the New York Times and from a blogger. They're all part of the freedom of speech that the First Amendment protects. And now that doesn't mean that the conduct that they engaged in may not be treated differently, depending upon what they actually do. But I think in terms of the nature of the institutions or individuals, as a practical matter, that's not going to be a sustainable line of inquiry.
Thanks. Thank you, gentlemen, for being with us today. I yield back, Mr. Chairman.
Thank you, Mr. Coble. I now turn to Bill Delahunt, the distinguished gentleman from Massachusetts.
Well, thank you, Mr. Chairman. And this has been a very informative discussion, and we're talking about legislation and you know, the problems that of drafting appropriate language and the issues of intent, et cetera. But I still go back to what I said initially. Until Congress, and particularly members of this committee, address the issue of the classification process, we're operating in the dark. We don't understand the classification process. I wonder if anyone on the panel really does in terms of the steps. Who classifies? I've heard some of you use the term improper classification. Who makes that decision? I've heard the term authorized leaks. What in the hell is an authorized leak? Is that a leak that, you know, someone in the administration can do, but we can't? What struck me, again, when I chaired the Oversight Committee in Foreign Affairs was we would get material that was redacted, page after page after page after page. All you knew or all you saw was the number. And then, of course, the next day you'd read in the newspapers, but I guess that was a good leak as opposed to a bad leak. So I hope, and I would direct this to my colleague from Iowa, I hope with the new Congress that Congress conducts a series of hearings where it demands an explanation of the process itself. Are we going to rely on a bureaucrat, you know, at a lower level to do the redaction? Who does all this? Help me with the mystery. Anyone here? Maybe I see you, Abby, nodding your head. Give it a shot.
I can't answer that question as a blanket fashion across all agencies and all parts of the Department of Defense and all places in the world. But I can answer it based on the materials I've seen on the cases I've litigated, and you're raising a point. So in the APAC lobbyist case, by the time we were done and getting ready for trial, there was no fewer than, I don't know, 4,000 or 5,000 pieces of paper that were in a classification mode at one level or another. There's an executive order which has criteria for why something's classified, very specific categories of the potential harm that the release of that document or information could cause. Like every other thing you've been talking about today, those aren't microscopic definitions in a mathematical way. They are subjective to begin with. One, for example, talks about interference with the nation's foreign policy or foreign relations or relations with a foreign country. I mean, what
does that mean?
Well, I mean, but then the second question is, who gets to decide, you've asked?
That's the key.
Well, in many agencies, what you'll find is that it's not the secretary or the deputy or the assistant secretary or its equivalent. It is the lowest level of person working on the subject who at the end of every day.
But that's my concern.
Well,
that's my concern. And I think that issue is the predicate for addressing the concerns that you as a panel have addressed. You've got to begin there. And we really have to do a thorough review, because I would testify in the next Congress that as chair of that committee, I saw material that was classified that it was absurd that it was classified. And we're just building up a backlog of classified information that that everyone in this room today would concur ought to be in the public domain. The concern that I have is not so much about WikiLeaks, but what we're not having access to in a democracy. And I hope that in the future it's addressed, whether it's in this committee or any committee. Maybe a select committee is actually needed. And people coming in who actually do the classification, not the secretary, not the head of the agency, but to hear it. Now, I had occasion working with Congressman Lundgren, where we had concerns about information that was being disseminated from the FBI. It was very revealing in terms of how it was done. And I'm not saying the classification was done in good faith, but it clearly did not, in my judgment, meet any kind of standard in terms of classification. That's got to be reviewed. Mr. Blank.
You've got a couple of great assets at your disposal for the next session. There is a terrific review board called the Public Interest Declassification Board, headed by Marty Fega, former head of the National Reconnaissance Office. It's a group of smart people who are looking exactly at these questions. Right. How do you change it on the front end so you don't, because every single classification decision that a lowly bureaucrat makes generates a stream of cost to the taxpayers and to the efficient flow of information that goes on indefinitely until somebody like me asks for that document to get released. That's a terrible way to do business. It should be automatic after a certain sunset on every one of these secrets. You can call in those Public Interest Declass Board folks. They can give you some expertise. There's a wonderful little office called the Information Security Oversight Office. Those are the folks that audit the secrecy system. They're smart. The head of that office is the guy who coined the term Wikimania that I've been using today in my statement. Call them in and give them some more resources. I think they got 29 people to ride herd on this massive overclassified security system. They need some help. But they can guide you through how does the stamp get made. And the last thing I would ask, Mr. Chairman, we've done about 4 different postings that support the consensus on the committee of massive overclassification. Congressman Poe commented on it, agreed with Congressman Delahunt. Actually, it seems that they actually agreed on this. This is actually a piece of White House email that is declassified by process 1 week apart. And the first time they cut out the middle, blacked it out. And the second time they cut out the top and the bottom. You slide them together, you got the whole thing. And the punchline is, it was the same reviewer, a senior reviewer with 25 years experience. Called him up, said, what's up with that? He said, oh, it must have been something in the paper about Egypt that week, but Libya this week. I mean, that's the level of subjectivity.
Exactly.
We've got about 5 or 6 web postings of these kinds of graphic illustrations of the overclassification problem that will help you get your arms around it, and I hope do something about it.
Who authorizes the leaks, by the way?
There's that famous quote from James Baker, the former Secretary of State under President George H.W. Bush. He said, the ship of state is a very unusual ship. It's the only one that leaks from the top. And I think Daniel Shore once commented when David Gergen was brought into the Bush White House, Jim Baker was too busy leaking at the high level, and he needs somebody to leak at the mid-level, right?
Well, what I find ironic, of course, is the umbrage that some will take about some leaks. But I guess it's not their leaks. There are good leaks and bad leaks, I guess, is the bottom line. Mr. Nader?
Congressman, part of this goes back to the integrity of the civil servant and protecting it and letting civil servants and people who work in the armed forces and the executive branch take their conscience to work.